This is Michael Popok, Legal AF. Ever have a credit card declined at a fast food restaurant and pulled out your gun and fired it into the air? Ever been involved with a car accident and then pulled out your gun and fired it at the person that was involved in the accident? Ever take a shot at somebody that you were in a romantic relationship with? Well, if you haven't, then you have nothing in common with Mr. Rahimi, who is actually at the heart of a Supreme Court case about whether people who are subjected to restraining orders as domestic violence abusers can also be found to have committed a felony if they have a handgun. In other words, can the federal government, without violating the Second Amendment, disarm somebody who is dangerous, who has been proven to be dangerous, and who has a domestic violence track record? Yes or no? Which society do you want to live in? Today was an oral argument at the U.S. Supreme Court about what Pandora's box they opened when in 2022, in the leading case we've talked about a lot here on the MeidasTouch Network on Legal AF, we call it the Bruen case. It's New York Rifle Association versus Bruen, and that's the one that established that there were very limited abilities for the state and federal and local governments to regulate any kind of gun ownership. In order to do it, Bruen says you've got to find an historical analog, and according to Clarence Thomas, who wrote that decision, that historical analog has to be sort of a similar regulation or a regulation that has similar underpinnings starting in 1791 when the Bill of Rights was passed, including the Second Amendment, to the Civil War. So if in that period of about 75 years, you can find as a government something that's similar to the ban you're considering, then you're okay. But if you can't find it from those old-timey days, then you're sort of shit out of luck, pardon my legal French, about regulation of guns. And that stuck a lot of people and struck them the wrong way about what is appropriate in modern society with modern warfare, with dangerous people, and what you can do to regulate them. In fact, courts since that decision in 2022 have been all over the map at the lower level federal courts and at the upper level courts trying to figure out how to apply Bruen. For instance, there's already been a series of cases that have overturned many gun safety laws, including, get this, age restrictions in Texas. So now a 6-year-old can have a 6-shooter, I guess, in Texas. Also, regulations, particularly that go to this particular case, this Rahimi case, about felons and drug users also having the ability to own a handgun. And so this all came to a head with the first opportunity for the U.S. Supreme Court to revisit gun control since the 2022 Bruen case. And let's just, no pun intended, let's just say the lawyers for Mr. Rahimi, who has not covered himself with any glory, and I'll give you more of the details of what he's accused of being. He is a piece of, what's the word I'm looking for? I'll say work here, in terms of how he abused his girlfriend and just the general public as a menace. They had to deal with the facts there. I mean, this Supreme Court doesn't like to deal with facts, but when they heard the facts of this case, they also took special delight, I think, in tormenting the lawyer for Mr. Rahimi, who was internally inconsistent in his arguments, so much so that even Justice Kagan said, you seem to be running away fast from your arguments that you made in your briefs because you can't support the logical conclusions of where they end up. In other words, you're on ground that's indefensible, is what she was trying to argue. But let me set up where we are, and then I'll tell you about what this guy's all about. And based on the oral argument today, where I think this court is ultimately going to rule, which is going to be to allow this type of regulation, even though there's not a historical twin, as they like to call it, in that 75-year period from 1791 to, let's say, 1865. So first, what is this law I'm talking about? It's 18 U.S.C. 922 G8, and it was passed in 1994 to stop domestic violence abusers, those that have had a restraining order against them, or convicted of that, from having a handgun, and making it a felony if they are found to have it, which would have led this guy to either not be able to get a handgun or a gun of any type, or make it a felony when he used the gun, had a gun after he was already the subject of the restraining order. And so that stayed on the books since 1994. Even the Fifth Circuit, which is a right-wing leaning circuit based in New Orleans and covers Texas as well, which has been sort of the bane of the Biden administration and all of his policies. Even they, before the Bruen case, the Supreme Court case from 2022, were like, yeah, this guy, that kind of thing, this kind of guy, that's got to be regulated. Sure. That, even this kind of Texas leaning court found the gun control in this situation was legit. Until Bruen came out, and they said, oh, wait a minute. Justice Thomas told us we have to look for like a historical twin or an analog. And I don't see the government really showing us where domestic violence people aren't allowed to have guns, even as logical as that sounds. And the government, through its Solicitor General, which is the person that argues for the Department of Justice in front of the U.S. Supreme Court on behalf of the United States of America, she argued, you don't go down to, and this is too literal, you don't look for an exact regulation that's exactly matching from 150 years ago. You just look at generally the proposition. Were dangerous people disarmed by our forefathers, our predecessors, yes or no? And if they were, then this type of disarming of dangerous people falls into that overall bucket. It can't be so constrained in the interpretation. Is there somewhere on the books from 1791 till 1865 a state that regulated and took away from? And the answer to that is probably no, because let's be frank, during that period, women did not have equal rights in this country, and they were treated like chattel, like property owned by their husbands. And things like killing them and abusing them were not the crimes that they should have been. And so you have that historical underpinning. As we modernize our progressive society, that has to be recognized as well. And so when I give you the list of the things that this guy Rahimi did, back then, and some of these things might not have even been crimes. Doesn't mean we're living in that lawless period where misogyny reigned and people were disrespected and women didn't have any kind of equality. I don't think we're in that society. I don't want to be in that society. So here's what this beauty did, which is the facts that support the case. The December 9th of 2019 started it all off. Rahimi throws his girlfriend, the mother of one of his children, to the ground, drags her through a parking lot, throws her into his car, bangs her head, causing a contusion on the dashboard. And when somebody tries to intervene, he pulls out a gun and shoots at them. Then about 2 months later, the girlfriend obtains a restraining order to keep him 200 yards from her, which he promptly violates later that month. And in fact, now he's got the restraining order against him. He can't own a firearm, yet he has a firearm and uses it to shoot at another woman. Wait, I'm not done. Then he violates the gun charge again in May 20th. They go and arrest him. They pick up drugs. He's like selling fentanyl. So they arrest him for drug use and he goes to jail. When he gets out of jail, he goes on a shooting spree. From November 2020 to January 2021, he's involved with 6 public incidents of using his gun, leading to 11 crimes being charged against him in Texas, including this felony of owning the gun. 2 of them, just to show you as I let off the hot take where I was coming from, one of them, he was in a car accident and he pulled out a gun and shot at but did not hit the driver. And the second one, he was at a fast food restaurant with a friend who had his credit card declined and he pulled out a gun and fired it into the air. Just normal behavior, which led to a very interesting exchange during the oral argument with Justice Roberts asking the questions or interjecting something that indicates where his head is at in terms of eventually voting on what to do here. They were busy, and I'm not just talking about the 3 liberal justices, I'm talking about the 6 right-wing MAGA were busy as justices with a very hot bench peppering this lawyer that represented Mr. Rahimi with questions that he could not answer, or at least ones that were internally inconsistent in his response. At one point, he said there can be no restrictions on any kind of guns. And the others, he said there could be restrictions if somebody is mentally ill. On the other, he said there can't be restrictions. There can be restrictions if somebody is dangerous, but he couldn't define what dangerous was, which led to this interesting exchange. There was a question asked by one of the justices on the Supreme Court today. What you heard Miss Pralinger, the lawyer for the government, the Solicitor General, and she said that there is a history in that time period that matters to us for gun regulation, 1791, 1865. There was a history of disarming people who were dangerous. And therefore, we should allow this because this is a subset of dangerous people. Let me ask you something, sir. Was your client a dangerous person? To which this lawyer answered, I don't know what that means. I guess playing games with the word dangerous. To which Justice Roberts, Chief Justice Roberts, not asking the questions, interjected, well, someone that shoots at people, that's a start. In other words, they are obviously repulsed by the facts in the case. Now, they'll often say that facts don't matter for the legal principles they're trying to establish, but here I think facts really matter. This is a disgusting, depraved, unhinged, violent human being that should spend the rest of his life in jail, if not worse. And the fact that he's the one that's carrying the water for the case that could lead, if they vote the wrong way, the other way, to violent people in our society having the right to carry a handgun, I think is not sitting well, even with this Supreme Court. And so when you have the Chief Justice jumping in with, you don't know what a dangerous person is? Well, a person that shoots at other people is a good place to start, don't you think? Because they know the historical record of all the things that I just described to you. The shooting at the girlfriend, the shooting at the second woman, the shooting in the air at the fast food restaurant, the shooting at the driver in a car accident. And I could go on, but I would rather not. So that's where we are. Based on the oral argument, which went on for about an hour and all the full briefing, I would, to be frank, even this Supreme Court, I would be shocked if they don't find, in this case, that government and governments have the right to disarm dangerous people, including those who are subject to a restraining order. Whether they also address the other issues, which are really not before them, about, restricting guns to drug convicts. And, I'm not sure they get there, but they will at least, I believe, use the opportunity to straighten out the confusion about the Bruen precedent and about whether there has to be once and for all an actual historical twin that matches line for line almost with in order to have a modern regulation, you got to find a historical twin from that 75-year period. I think they're going to say you're reading it too literally. We just mean, is there a policy broadly about a certain type of regulation, dangerous people, drug users, this or that, not specifically go find me where, in 1862 Oklahoma, there was an analogous rule or regulation on the books, or we'll have to strike this one down. So I think they'll clarify that. We'll follow it. We'll probably get a ruling, certainly before the term is over in June, maybe before that. Usually it takes about 4 months or so. So it'll be sometime in March or April, and we'll get a decision from oral arguments that are being heard now, with the court back in session now in the second month of its term. This is Michael Popok, Legal AF. We do hot takes, or I do hot takes just like this one, at the intersection of law, politics, and justice in one place, the MeidasTouch Network exclusively. And then we pull it all together. And if you like hot takes, I like them. you're going to love what we do on Wednesdays and Saturdays in a podcast we call Legal AF. It's exactly what you think. And we do 4 or 5 of these stories. I got a co-anchor on Wednesdays. Her name is Karen Friedman-Igniflo. I got one on Saturdays. His name is Ben Meiselas. And we debate these issues with our collective 75 years of legal experience as practicing lawyers. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.